probably be okay with that.
I recognize that I'm the last person between you and Arturo's restaurant, and so I will try to be succinct. It's my privilege to testify before you by way of brief background. I moved to the Rio Grande Valley in 1986 after graduating from SMU Law School. I practiced law here in the Valley for the entire 36 years of my career. For 29 of those 36 years, I've represented local governments, which has included cities, special districts, and yes, I've represented water district. And for 27 of those 29 years, I served as legal counsel to the city of McAllen, including 14 as city attorney. I've had the opportunity in that capacity to testify before this committee on a number of occasions on this topic. Either this committee or related committees on bills that have been presented over those 27 years. And so I would happily refer to my previous testimony as I have not changed my position on the statements that I made at that time. I'm only going to touch on the big picture very, very briefly, as Mr. Vega ably testified, that I would simply say that as this committee has heard, this district is 101 years old. And the original purpose for that district, serving the thousands and thousands of acres that existed within the boundaries of the original district, is now almost completely urbanized. It's certainly not the fault of the current, or anyone's fault, that the boundaries have urbanized to that extent over time, but what it has created is a situation which I refer to in my statement, and I'm sure the committee members are the infamous buggy whip subsidies that the federal government gave out long after nobody was driving horses and buggies anymore. The subsidy continued and was hard to get rid of. That's sort of the situation as I have characterized it over the past years with respect to District 3. As the Senator said, there are nearly 24 other districts within the Valley. I happen to represent one of those other districts. And the fact of the matter is that they simply don't have the level, unfortunately, the level of antagonism between them and their customers as District 3 has developed over the years, which certainly predates the current board members. I'm sure it probably predates me, but that is the situation as it exists. There has been consolidations of districts over the years to address this urbanization problem. There have been agreements made between the cities and districts throughout the valley, and they have been able to resolve these urbanization and change of landscapes very efficiently, but for some reason, not at District 3. I could give a variety of examples of how this district is what I would call as an avowed conservative, as an unnecessary level of government that served a useful and valuable purpose at one time, but now is simply adding a layer of expense because essentially what they are doing, notwithstanding the small number of farmers that they serve, what they are essentially doing is taking water out of the river, pumping it a few miles in an underground canal into a reservoir owned by the city of McAllen. That's reflected in the budgets, it's reflected in most of the testimony today. You simply don't need an additional layer of government to do that. It's of course for this committee and by extension the legislature to decide what, if anything, you want to do about solving those problems. I understand that. We've asked several times in the past. We had a bill made it all the way to the governor's desk during one session. And so I stand by my opinion, which is that they should be folded into the city, which is the primary customer, and that those remaining farmers can either easily be served by the city, as Mr. Vega testified, or in some cases, they might actually be better served by an adjoining or a nearby district, which could do that more efficiently, perhaps in District 3. In fact, Mr. Brand alluded to in his Mr. Vega in his testimony that they were extending their facilities out to the north. Well, what he didn't specifically mention is they're extending them well beyond the original boundaries of the district. So they are now well north, or trying to go well north of where the original district was, and that's because within the original boundaries of the district, there are no more new customers to serve. And also was not mentioned in that testimony that the customers they're trying to get out there currently belong to another district. So in their effort, perhaps, reasonable effort to go fishing for new customers, they are far exceeding the boundaries of the existing district, and they're going after customers that belong to other existing districts. That's the subject, Mr. Chairman, of one of the lawsuits that you asked about earlier. But here today, Mr. Chairman, members of the committee, in the time that I have, other than answering questions if you would like, I'm only gonna focus on one thing, and here I don't know whether I'm gonna get sympathy or I'm gonna get arrows. But two things. I ran for the district board of directors last May, so I had to deal with the infamous list. I'm also, Mr. Chairman, one of those 1.5 meter guys. I acquired a 1.5 meter piece of property within the district for the sole purpose of being able to run for the board of directors. I did not mention that, or maybe I did. In January 2021, I left the city of McAllen. I want to be clear about that. I'm no longer the city attorney for the city of McAllen. I'm now in private practice of law, and represent a number of local government clients, private sector clients, and I run the business office at my church, which is a bit more common than water district business, but not necessarily as much as you would think. So at this point, Mr. Chairman, I would like to turn to my prepared comments. I decided this spring, along with former Mayor Jim Darham and another colleague of mine, to run for the 3 seats that were up on the district board. We thought we might be able to affect change at the district with 3 new members on the board. Well, first of all, Mr. Darling was not allowed by the board president to run. He also had acquired land within the property. I understand Mr. Brand doesn't seem to like that. He didn't mention, I think it's still the case, that one of their current board members is in that exact situation. Mr. Darling, myself, and my colleague all acquired a small piece of land within the boundaries of the district so that we could run. Mr. Brand, as board president, on the advice of their board attorney, declared Mr. Darling ineligible. I have, for the committee, and again, I'll submit it for the record. A response to that, the unilateral decision that either Mr. Brand or the board made not to allow Mr. Darling to run, but I will summarize it for the committee and say that the decision was both not in compliance with the election code and it was not substantively correct. Nevertheless, we went forward with the 2 of us that were there. I lost. And my colleague lost. I received a grand total of 16 votes. My colleague received 26 votes. That sounds pretty bad, but as was testified here before, what you should know is that the winning candidate got about 58 votes. This isn't a district that charges the ratepayers of McAllen $1.5 million and directly provides the primary ingredient in the drinking water within the city that contains, as Mr. Vega testified, 160,000 people. This is not apathy, Mr. Chairman. It's because the overwhelming majority of people that are within the original boundaries of the district are no longer allowed to vote. Those 90 votes, which is the combination of the losing candidates and the winning candidates, actually represents about 30% of the registered voters, because as Mr. Brand testified, there are, and I can say with a reasonable degree of certainty, 335 persons that are eligible to vote in this district. Only 194 of them live within the city of McAllen. The other 100 live within the city of Hidalgo, which interestingly does not receive any raw water from district number 3, despite having nearly 45% of the voters within their city, because they don't have a water plant. They use exclusively groundwater for well water for their citizens in the city of Hidalgo. I'm going to diverge a minute and say I was able to produce a voter list. The reason I was able to produce a voter list is because, as Mr. Brand testified, not because they had one, and not because I could get it from the county, but I used private resources. I happen to be fortunately associated with the law firm of Bickerstaff and Heath, which I'm sure some of you all have heard about. We do a lot of election law work, so my law firm has the county voter database. So we requested, and again, I have it, I'll submit it if the chair likes. I requested in writing a copy of the voter list so that I could run, well, along with my colleague, and at the time I thought Mr. Garland, for this seat on this board. They did not produce ever a voter list for me. Not at the time, not at the beginning of early voting, and not before the election occurred. I had to generate it using our own private resources ourselves. And what we did, very simply, was we took the maps that were provided by the district about 60 or 70 days before the election. I sent them using, again, private resources to my law firm, who then overlaid the voter map, the boundaries that we were given by the district with the county database of voters. And they did some sort of voodoo, Mr. Chairman, that merges those CAD files together, and they sent me back a list that contained 335 names, which we then assumed were people that lived within what they now call the boundaries of the district. That's how we did it. Why they couldn't have done that at the county, I have no idea. But we had that list, and that's what we used to campaign. Obtaining the list, despite the previous testimony, is really only part of the problem. The larger problem, Mr. Chairman, is how did we get from having 140 or 150,000 people within the boundaries of this district to 334? How did that happen? It happened through the systematic removal of property by the district board of directors. Now, Mr. Brand has touched on that a little bit, and I think Chairman Canals has been provided a map that shows what Mr. Brand now calls the Swiss cheese, but what he didn't talk about is the process by which that happened. For example, in 2012, I was still working at the city at that time, I, along with Mr. Darling, recruited a person to run for the board of directors who lives in my subdivision, Mr. Chairman. As, of course, do I and about 70 other people. That person, by the name of Freeland, was elected with our assistance to the board of directors. Because at that time, that subdivision was included within the boundaries of the district. But guess what happened immediately after he got elected, Mr. Chairman? That subdivision, along with a whole bunch of others nearby, were excluded from the boundaries of the district. Now, I understand that also the water district representatives are quick to try to say, well, that's because you didn't get water. We hadn't gotten water for 75 years. It was only when people from my subdivision started running for the board that suddenly it became necessary to remove my subdivision and me, which explains, by the way, Mr. Chairman, Representative Paul, why I did the 1.5 meter thing. I owned land within the original boundaries of that district and have resided there for years. But when I recruited a neighbor to run, then my subdivision suddenly disappeared, as began happening all across the city. Now, before they start talking about delivering water, let me say, and you alluded to this, Mr. Chairman, you talk about campaigning. Well, we did campaign, and in fact, during the course of the 4 or 5 weeks leading up to the election, between my colleague and myself, I would venture to say that we knocked on the door of virtually every single house that was on this list that we created with our own resources. But here's what we discovered. We discovered 2 interesting things. One is that you can walk down the street, and I'll mention some of them for the local representatives, like Tamarack, La Vista, Hackberry. You can walk down that street, and what you discover is this. These people are in the district, but their next door neighbor's not in the district. 2 houses here are in the district, but the person across the street is not in the district. So to suggest that this is some sort of systematic decision on the part of the district to do something other than eliminate properties based upon voting patterns is disingenuous. Now, we did find an interesting fact out about the voters in Hidalgo, the city of Hidalgo, a great city to the south of the county. One entire subdivision, which represents almost all 100 of the voters, about 100 voters in this one subdivision, are a cohesive subdivision. Guess who lives there? paid members of the District 3 staff and their families. So this is how the exclusions have occurred. And I wouldn't be a good government lawyer if I didn't make this point, Mr. Chairman, which you may remember from years ago. Many of these exclusions occurred prior to 2013. That's an important date because prior to 2013 and the Shelby County ruling regarding pre-clearance, any of these exclusions were supposed to be pre-cleared by the DOJ. They never did that. They never did that. And when the representative was asked at a hearing why that occurred, why that didn't occur, his response was, we just decided that law didn't apply to us. That was their response. By that time, they were well on their way to excluding the voters. Now, here's the thing, Mr. Chairman. There is no, I know this sounds outrageous, and I apologize in advance for it, but there is no logical reason why they would ever stop removing voters from the district. I can't find anything in the law that would require them to have a single voter. As long as there was still a piece of vacant land in the district, they can have a district with no voters. And in fact, I mentioned 335. What I didn't mention is the number would have been considerably smaller if Mr. Brand had had his way at the very last exclusion meeting of the board of directors that occurred about 2 months before the election. Only through the efforts of one of the board members, coincidentally Mr. Freeland, who was my neighbor, who ran and then had his subdivision removed from the district, and who I think now owns 1.5 meters or a couple of meters within the district himself, an incumbent board member, he stopped it. He was able to stop some of them. Otherwise, the number would be much, much lower. And as I say, I don't know why they would stop. So here's my only point about this, Mr. Chairman. What this committee and the legislature decides to do with the district, I'm on the record and I have my opinion about that. But please don't assume that these problems are going to be resolved by the voters of the city of McAllen being able to elect people on the board of directors to affect change, because it cannot happen, and it will not happen. You may wake up between now and the next legislative session and find out there's 50 voters in this district. So changing the board of directors is not a viable solution to these problems. I had a couple of points that I wanted to make for Mr. Brand's the efficiency. I'm on only because I was there at the time. We have, over the 27 years that I was with the city of McAllen, we did run pro formas about how the city could run the district, and in every single case, which I believe was presented, Senator, at the previous hearings, it would save taxpayers and ratepayers hundreds of thousands of dollars to have this as a single entity rather than two entities, and that's without that's without trying to put a price tag on the removal of this animosity that has occurred. That's all I have, Mr. Chairman. I'd be happy to try to answer any questions.
Thank you, and I apologize. I only gave you 1 square meter, and you say it's 1.5 square
I
meters.
believe so.
Any questions? Chairman Canales?
Thank you for being here. Your testimony is very interesting, and I don't have any reason to doubt it, because I know anybody else's, but it's true. It's extremely troubling. I just want to clarify this. When you said you requested the list, did you do that by way of public information request?
I put it in writing at this, and I have a copy of the letter. I'd be happy to provide it.
Was it
Mr.
a
Chairman. It was, in all honesty, well, first of all, I know a little bit about public information. And so I would say that it would definitely qualify as a public information request because it's in writing and that makes a request to the district. It was filed at the same time.
Was it a lawful request?
Yes, sir.
Was it responded to?
No, sir.
Do you know of other instances that you have personal knowledge of where people have made lawful public information requests of the district and didn't get response?
Yes, I do.
How many that you can think of are just off the top of your head?
I would say that over the years, it has to be more than a dozen.
More than a dozen in your mind?
Over the years.
Okay. And your testimony is today Oh, that's what I was gonna ask you. Mr. Brand, I asked him directly, have you ever had somebody claim to be qualified on land that you removed from the voter list? And he said unequivocally, no. So you're telling me that Mr. Darling was making claim that he had land?
Yes,
He was claiming to be a registered voter?
yes.
He was claiming to have that 1.5 meter, whatever it is, and he was removed from the voter list?
He wasn't removed from the voter list, Mr. Canales, he was declared to be ineligible to run for the board.
Maybe I should have asked a clearer question, Mr. Brand. Then, and I just, so that I'm clear, it's your testimony that I'm understanding, that you're saying the systematic diminution in the amount of boundaries, your analysis, what you're telling the committee is that that is being done for the single purpose of controlling the election process.
I can't say it's the single purpose, but
What other
it
purpose?
certainly appears to be motivated by.
What other purposes could there be?
I wouldn't know, Mr. Canales, I mean, removal of property, as Mr. Brand testified, from districts that's no longer irrigation in and of itself is not terribly unusual, but not to this degree with this pattern.
So that's the question. So there's a systematic diminution when the property is not being used, as Mr. Brand said. But your testimony is that there's one house that's in it, the next one is not, two that aren't, one that is. And so
Yes, sir.
is there any rhyme or reason that would give you, that would justify another reason other than the systematic removal to control the electoral process?
I can't think of it.
Thank you.
Just a couple of questions, I guess, from your testimony and from what I know. Seems like, Water District Number 3 leadership manipulates elections by eliminating subdivisions, potential candidates who run against incumbents, or potential voters who would otherwise vote and support a challenger to the board member.
It's certainly what it appears to me to be, Senator, including my subdivision, which, as Mr. Brand alluded to, I was the one that recruited him and got everybody in my subdivision to vote for him.
And I know, water rights are very sensitive, as the chairman mentioned, but I sometimes thought about, it takes 2/3 vote to suspend the Constitution. And we do that on a regular basis. I really don't see that as an obstacle, for this type of situation. We've done it in the past. And for me, what's really paramount is that you testified that Water District Number 3 was trying to expand beyond its boundaries, and most likely using McAllen taxpayers to be able to finance or at least try to expand beyond their jurisdiction.
At the time that I left the city, that was in progress, and it certainly looked that way to me, so.
And actually, there was a, well, I won't get into the litigation part, but this has been going on for years, and regardless of how hard Senator McCarran has tried to negotiate with the Water District Number 3, there seems to be a lack of cooperation as compared to other water districts and irrigation districts, where they work to resolve problems, work out issues. Here, it doesn't happen.
Well, for the entirety of my 27 years, both things were true. Senator, was that the relationship was difficult, and we tried to work things out. I do want to be clear that by working things out, it did not necessarily mean elimination of the district. When Mr. Brand was asked to run along with another colleague, and they were both elected, they were asked simply to support an effort by the city of McAllen to enter into a management agreement which would save the district and its ratepayers money, and allow the board and the entity to continue to exist, but under this management agreement, which, by the way, he agreed to support at that time. So there have been, my point is very simple, we have made good faith efforts over the years to try to resolve this amicably without having to come all the way to Austin. which is, all due respect, not terribly pleasant for us as well. I say us again, let me be clear, I no longer speak for the city of McAllen, speaking as a private citizen.
Well, and there hasn't been change in the leadership for years and years and years, so obviously, it's very difficult to continue to try to work things out when they refuse to cooperate. And what's really, in a sense, I'm a citizen, I live in McAllen, an insult to injury is they're using our taxpayers' money that the citizen can pay. They're using the increase in water rates that the city of McAllen pays to Water District 3 to litigate issues against the interests of the citizens of McAllen, and to hire lobbyists to work in the legislature against the interests, the best interest of the city of McAllen. It just, that's what's happening, and it's hard to sometimes communicate that to the general public of what's going on about this remotely. But thank you, Mr. Pagan.
Anybody else?
One follow-up. You represent McAllen for 27 years?
Yes, sir.
In the 27 years you were there, I asked the witness before you, but he didn't see, he had an opinion, it sounded a little shaky, not that he wasn't being truthful, but it seemed like he didn't know. And so, you might be able to give me a more clear-cut answer. What, in your 27 years, while you were there, would be the comparative litigation climate with Water District 3 as opposed to any other water districts? Can you tell us what was going on legally during those 27 years as far as litigation with water districts in McAllen?
Yes, Mr. Canales, if I could, is to kind of make 2 points. One, when you asked that question, of course, it was, dinging on radar. I honestly cannot recall during my 27 years of us engaging in litigation against any other district of any kind, including condemnation. By the way, and if I could add this, maybe make the point, I don't recall during my tenure us instituting litigation against District Number 3.
Was there litigation with District Number 3?
And I don't know. I
You
think
don't know
not. I think not litigation, but the reason was very simple. Every time that we would get to those points, say that or condemnation, we had this exact discussion. We're gonna file this lawsuit to try to make this happen, and then the district is, in effect, going to use our money to defend litigation against us and then raise our rates. So we tried very, very hard not to engage in things that required out and out litigation. I understand that there is some, and there might have been one, same way with condemnation. And by the way, it's a whole nother discussion, Representative Canales, but the way the acquisition along Bicentennial was described left a few details out. Yeah, to fill those in for you because I was up in my elbows in that. But no, we tried, the city of McAllen tried very, very, very hard not to institute litigation against anybody, but certainly not against somebody that was spending our money to defend themselves from us.
Okay, thank you.
So, you said you represented another water district, or
Yes,
did, or used to, or maybe currently
I still do, for
So-
29 years.
Yeah. These other water districts, do they sell the majority of their water to the city of McAllen, or do they have a little broader customer base?
The one I represent,
Let's just take that one.
the one I represent does not sell any water to the city of McAllen. It's jointly, it's called Irrigation District Number 16. It was the very last one created. It's way out in the northwest part of the county. They have municipal customers, Mr. Chairman, but McAllen is not one of them.
I see. And so I think the city of McAllen, Mr. Vega told me before the meeting that I had in the testimony that something like 40% of the water that McAllen uses comes from number 3. Yeah, he's nodding his head, yeah, so I remember that number right. So, it just occurs to me that when you compare it to these other districts, part of the reason that there's animosity, which can happen in families too, is that they for all practical purposes have one primary customer, and that's you. And you got 40% of your water, and it's kind of like being locked up in a room
Yeah,
again.
well, that's a very good analogy, Mr. Chairman, in this respect, and at the risk of wading into that, no pun intended, let me say this. The reason for that is not only is it a take or pay, but it's an exclusive contract. So the reason that, in my opinion, that the rates are different is because the city can't have another district pump that water. So it is not an arm's length negotiation, it is a perpetual
I
contract.
don't
in which
understand what you mean by that.
The original contract that Mr. Brand alluded to, which respectfully I think is a little older than he suggests, I'm not positive. But the one for the 8,000 acre feet that Mr. Vega testified was a take or pay contract, that is an exclusive contract. We can't move that water and have anybody else pump it for us. It has to be pumped from District 3 because they were the original owners of those water rights, which Mr. Brand testified correctly, were allocated to the city of McAllen as exclusively for the
Okay,
city
so
of
that kind of
McAllen.
gets us a little bit to what I was trying to get an answer to earlier. So you're saying that those water rights in that take or pay contract were water rights that they owned, number 3, owned, más o menos, more or less,
Mhm.
and they allocated those exclusively
Right,
to
they
the city?
converted them to municipal rights and
Yeah,
they
he did say that, didn't he?
adjudicated to the city of McAllen, which means that they can't sell them to anybody else or pump them to anybody else. And conversely, the city can't acquire that, have anybody else pump that. So your analogy being locked in a room together was closer than you thought, Mr. Chairman, because, the city has to, and when you couple that with the fact that it's take or pay, then you're gonna pay that money, no matter whether you take that water down or not. Further, and I'm not casting aspersions at whoever drafted that contract, but it more or less gives the district unilateral right to change the rate.
Well, and so,
I understand that's a subject to litigation now. so.
you heard my frustration about determining what water they're buying and what water they're not buying, and whether or not that allows the city of McAllen, water, whether that goes against the 38,000 acre
Yes,
feet of
sir.
water rights
Yes,
they
sir.
have. You got a comment on that? Is there a previous attorney?
Yeah, yes, we can't. It would go back to, if the legislation so ordered, it was always our understanding in this previous bill that the water rights would remain with the city of McAllen because they were adjudicated to the city. We did it, in fact, one session, if I recall,
Mhm.
attempt to pass a bill that would simply allow us to have another district pump that water.
Yeah.
And of course, the district opposed it because the minute that we're able to do that, then they're out of business.
Well, what I was trying to ask, because we keep going in circles here, so the city of McAllen, not that it's relevant, but I just wanna know, the city of McAllen has 38,000 acre feet of water rights from the river
Yes, sir.
to be delivered by some manner.
Yes, sir.
They're getting 8,000 acre feet from number 3, okay? It was adjudicated to them at some point, adjudicated or just assigned?
I believe it was
Contractually?
adjudicated. I believe it was adjudicated by the water rights. I could be wrong. about that.
Okay,
Maybe
may have just been contractually, we don't know.
This, yes.
I'm not accusing, I'm just asking. And so, they take those 8,000 from number 3, does that mean they still have 38,000 acre feet of water rights that they could get from some manner?
Yes. But they would still have to pay for the 8,000.
Well, yes, because it's a take and pay
Because it's
contract,
take or pay.
right? Yeah.
So, and given the fact that the district has the unilateral right to change the amount, then they would just be writing them a check for $1.6 million every year and not getting anything in return.
I think I know a tiny bit more than I used to representing Canales.
I'm more confused, so the witness before you testified that the water per acre foot that was delivered by district number 3 was not taxed against the 38,000 acre.
I don't know what he meant by that.
Okay, well, I'm thinking I do, is that you're saying they got 38,000 acre feet, but they also have these that they've got, that are now theirs contractually, so it doesn't tax the 38,000 because these are tacked on to your
No,
38,000.
There's 8,000 that are different than the other two.
Yes, I agree, and since
So these other 30 are more of an arm's length transaction, free market kind of deal. The 8,000 are the part of the original adjudication that is also part of the take or pay that the city has to pay whether they take them down or not. They would not have to have them pumped, in answer to the question, they could just say, no, don't pump us any more water. They probably have enough to do that, but they would still have to pay for it,
no matter what.
no matter what. Unless the contract is obviously set aside.
I'm getting thirsty.
Yeah, I think that's the subject, as you said, of one of the current lawsuits.
Yes, sir. I believe so.
All right, thank you for coming, I appreciate it.
Thank you. Thank you, sir.
So, is Is there anyone else wishing to testify? Mr. Brand?